addition to that, last October, the equivalent of this meeting, remember that Lou DeLuca submitted some of the Supreme Court decisions that have been done on this, and you basically find that political signs are protected.
They are protected within limits. They're not. It's not unconditional. The situation we have here is the regulations, as they read now, are in effect. And until such time that either the regulations are changed or a court issues a verdict, these are the regulations that we have, and these are the regulations that we shall follow.
Mr. Clark, I dispute that note, and I would like to say why. The state constitution and state law, if someone presents this to the zoning board, that trumps any local law. And what we would like to do is make the case as to why we can document clearly right now the state constitution, which is a higher governing body than local regulations. Excuse me, sir, I don't appreciate being waved off. You're supposed to be hearing and you're waving me off when I'm saying this. That's not fair.
What were you doing?
When I was speaking, you're turning your head and waving your hand off as if you don't like what I'm saying. Well, okay. If you're not, then I will take you at your word.
Thank you.
The issue here is, I can read you right now out of the state constitution, Section 4 and Section 5.
Without reading the entire statute?
No, this is probably less than 100 words between the two of them.
The entire statute or a selection?
No, this is the state constitution, Article Section 4 and Section 5.
Go ahead.
Mr. Murphy originally stated that state statute trumps local law. I agree with that. State constitution is not state statute, sir.
Right.
State constitution is the entire governing guidelines for the state of Connecticut.
No, it's not. It's not. That's why there are laws.
Look,
State statutes are
by
entirely
ruling, you let Mr. Arras speak. I simply wish to speak this in the record. If you wish to dispute it, that is your right, but I just wish to make the defense since he's asked me here on his behalf. Section 4 of the state Connecticut Constitution. Every citizen may freely speak, write, and publish his sentiments on all subjects, being responsible for the abuse of that liberty. Section 5. No law shall ever be passed to curtail or restrain the liberty of speech or of the press. Given that this states about free speech, expressing political opinions, of which Mr. Arras has, in addition to it, you folks have a legal opinion that this is something where you can agree or disagree with us, but this is the case that we're making to you. I believe it's the 5th paragraph, I have it highlighted. Because the restrictions on political signs contained in Section 7.5.10.I are greater than those applicable to commercial signs, I believe that there is significant risk that those restrictions would be found to constitute an unconstitutional restriction on free speech.
Until such time that a court determines that what the attorney believes these regulations stand. It's as simple as that.
That is your opinion, sir.
No.
You have the right.
Do we really want to take everything to court?
We don't have to take it to court. If
That's what you're
wait
saying.
Wait a minute.
That's what you're saying.
No,
We
not.
have to take
Yes,
it
you
to
are.
court.
There is a second possibility, and that deals with the change in regulations. We don't know. There is a possibility that the regulations will change to conform with any objection.
They're more restrictive.
They're more restrictive than they were in this.
And
Not from what I read.
Sir, and they're still out of violation with this legal opinion. I spent a whole day reading
On the
this.
commercial signs for contractors, it's got a 24 square foot restriction on it, which is...
That can change.
That's the new...
No, that's not the new. We haven't voted those things. Those are proposed. Those are not passed.
Correct.
Okay, but we're here today about the sign that's out there today.
Right, and as of now, that sign is in violation of the current regulation dealing with the sign.
And they're doing what they're supposed to do, which is to provide evidence as to why they're not.
Right, and I'm abiding by my Constitution. I'm sorry.
You may do that.
Thank you. I intend to continue.
Right.
I think for clarification, that the point that's being made here is that, I mean, the attorney says right in there, it's impossible to say until it goes to court.
Right.
And so I started off saying that we're not attorneys up here, and we're not, a lot of us have done our own research on this, and it's kind of indeterminate. Right?
Well, as
So
Ron said, do you want to go to court over this? And it's just,
I'm
the
not-
Constitution is pretty clear cut.
I'm not
And what
suggesting
Lou-
that, nor am I being argumentative. I'm just trying to state the fact that none of us are attorneys and have a legal opinion which would hold up in court. Only a judge can do that.
Right, but you can't guide and censure political input.
And that's why you have the outlet to come in and discuss the
Right,
zoning
and that's what I'm doing.
And there's another problem that I have too, and that's with the other legal opinion that Mr. Overton is holding, client privilege, which deals with this same type of thing. And, you know, he isn't letting that out to the commission. I don't see that he has privileges over the rest of the commission. He has no more privileges than all of us. We should be able to see that legal opinion.
You can take that up with him. I can't discuss that since he's not here.
I'm glad you brought that up, Ron, because the other thing is, it was asked for on behalf of the commission, and I've been at all your meetings, and I even FOI documents and any minutes or recordings or emails as to when that was decided to go for another opinion or clarification. I mean, you've been at the meetings. I mean, it didn't take place in this room.
Right.
So who decides this on behalf of the commission to go for another meeting?
It may have been the planner. I have no idea.
Well, here's the thing, is that at the July meeting, of which there's a video record of, and obviously an audio record because we tape it, Mr. Overton states that he refers to specific items in this. And it's highly likely, given number one, that by state law, all members and alternates of the commission have to get all the same information. Mr. Monti, you're an alternate, but you should have the same information. The spirit of it is, let's say that, you know, Mr. Cosgrove's absent, he may have to vote. So there's a legal opinion that the entire commission has not gotten. Mr. Overton admits this. There may be something in that. I don't know this.
At such time as the chairman presents an issue that would require that documentation to be distributed to the members, it can be distributed to the members in executive session.